Good afternoon. Welcome to this special online event celebrating the 20th anniversary of the establishment of the Special Court for Sierra Leone. The Special Court for Sierra Leone, also known as the SCSL, was a hybrid international tribunal established in 2002 by the government of Sierra Leone and the UN to prosecute individuals for atrocities committed during that country's horrible civil war. It is appropriate for Case Western Reserve University to be hosting this event since it played a role in the tribunal's success. Our War Crimes Research Office prepared dozens of legal memos on cutting-edge issues for the Office of the Prosecutor of the Tribunal, ranging from the issue of whether recruiting child soldiers was a prosecutable offense to whether forced marriage should be recognized as its own category of crime against humanity, to whether Charles Taylor, the president of Liberia, should have head of state immunity. We were humbled when the Office of the Prosecutor recognized the value of our assistance with a Nobel Peace Prize nomination. I'm Michael Scharf. I'm the Dean of Case Western Reserve University School of Law, and I will be moderating today's roundtable discussion with 6 of the individuals who played a critical role in the success of the Special Court. So with us today are Ambassador Hans Carell. He was the UN Undersecretary General for Legal Affairs who drafted the creative documents for the Special Court for Sierra Leone. We have Ambassador David Shepard. He was the senior American official who led the international effort to create the Special Court for Sierra Leone. We have with us Professor David Crane. He was the founding chief prosecutor of the Special Court for Sierra Leone, who issued the indictment for Charles Taylor. We have Brenda J. Hollis, a chief prosecutor of the Special Court for Sierra Leone, and later, and currently, international co-prosecutor of the extraordinary chambers in the courts of Cambodia. We have Binta Manasari, the Register for the Special Court for Sierra Leone and the current Register for the residual Special Court for Sierra Leone. And finally, we have Professor James Johnson, the current Chief Prosecutor of the residual Special Court for Sierra Leone, and he's also director of the War Crimes Research Office at Case Western Reserve University School of Law and my colleague. I will begin by asking a series of questions to our panelists, but we're encouraging the audience to participate as well. You can do this by clicking on the chat and adding your questions. And at the end, we will answer your questions and have the different panelists address them. Now, to set the stage, let's begin with Ambassador David Shepard. David, you were U.S. Ambassador at Large for War Crimes issues during the Sierra Leone Civil War. Can you tell us a little about that conflict, the sides that were involved, and the atrocities that led to the creation of the Special Court for Sierra Leone?
Well, thank you very much, Dean Scharf, and it's a great pleasure to be with all of my colleagues on this panel and to speak to such a large audience about a very important historical and still active court, the Special Court for Sierra Leone. This began really in the 1990s. There was a raging civil war in Sierra Leone, as there were in many other parts of the world, but this one was particularly acute and certainly rose to the attention of policymakers in Washington, which is where I sat as an ambassador at large for war crimes issues and dealing with policymakers in the State Department, the Africa Bureau, the Secretary of State, the Deputy Secretary of State. All of us focused on what was happening. 50,000 people died and were killed in the civil war in Sierra Leone. There were various factions, rebel factions. One was called the Revolutionary United Front, another an ex-army insurgent group called the Armed Forces Revolutionary Council. And these were opposed to the government of President Kaba at the time. It was a power struggle within the country, but there was something very unique about the civil war and the carnage of it, which frankly, reminds one of the unique character of the Ukraine struggle, where the destruction of civilian settlements and towns and municipalities and cities, along with civilian populations, is a sort of terrorizing event in the Ukraine conflict. Well, in Sierra Leone, it wasn't bombing, it was literally mutilation. Those who dared to vote, go to the ballot box and vote for President Kaba and his party, the ruling party at the time, the rebels would take these individuals aside and chop off their hands as a symbol of, well, you used your hand to vote, so now you don't have your hand anymore. And they extended that to limbs and feet. And so an entire class of mutilated individuals, civilians, people who were not associated with any fighting force, was created in Sierra Leone. And I visited Sierra Leone many times during the conflict, and you would see the mutilated populate the streets, populate the hospitals. So this was a form of terrorizing the civilian population, and that phrase came up in the Charles Taylor trial, as I'm sure Brenda Hollis and David Crane will point out. It was a terrorized tactic of warfare in the Civil War, and it was so gruesome that it emphasized the importance of the Civil War to policymakers elsewhere in the world. In fact, the operation led by RUF and AFRC was called Operation No Living Thing, just to further terrorize and intimidate the population. I'll simply say that this conflict continued, particularly in 1998. There was a lot of atrocities taking place. And then in early of 1999, the capital of Sierra Leone was under siege by these rebel groups. It became extremely gruesome. Atrocity crimes were occurring throughout the neighborhoods of Freetown. And that led on a diplomatic front to something called the Lome Peace Agreement of June or July of 1990, or July 7th of 1999, which was a negotiated deal with the rebels, but it included a very incendiary clause in it, which was an amnesty clause. And that was negotiated particularly by politicians who negotiated that. It did not really have the input of either myself or of UN lawyers, I don't believe. And in fact, in the aftermath of the Lome Peace Agreement, Kofi Annan, I'm sure under the close advice of our colleague Hans Carell on this session, put out a reservation to the Lome Peace Agreement that stated the United Nations holds the understanding that the amnesty provisions of the agreement shall not apply to international crimes of genocide, crimes against humanity, war crimes, and other serious violations of international humanitarian law. Well, that became extremely important because the Civil War erupted again. And by early 2000, it was the situation was unraveling. Even the talk of a truth commission was unraveling at that point. And then the final kicker was the kidnapping of UN peacekeepers in May of the year 2000 by the rebels. And that, of course, seized acute attention, not only by major governments, but by the United Nations itself, by Secretary Annan, Secretary General Annan, and that started to motivate a process that by early May of 2000, when hundreds of UN peacekeepers were still under hostage situations, they were still kidnapped at that particular moment, but that is when the real discussions about accountability commenced. And I'll leave it at that for now, Michael.
You know, Dave, your story reminds me that there is a context of atrocities that gets the world's attention. behind the creation of every new international criminal tribunal, but it's human beings, it's leaders that make these things happen. And I want to ask you as a follow-up, what role that you personally played during the creation of the tribunal? Tell us about your own story here.
Well, I had the advantage of being the first ambassador at large for war crimes issues, which was created under Secretary Albright and President Clinton in the second term of the Clinton administration. And it was specifically created for lots of purposes, but one in particular was to inject me into policymaking discussions at the highest levels of the US government, so that the issue of accountability and atrocity crimes was front and center in those discussions. So I had the benefit of being in so many of these discussions where situations around the world would come up every day. And one of them was Sierra Leone. So, I had a close working relationship with Assistant Secretary for Africa, Assistant Secretary of State for African Affairs, Susan Rice, and we would sit in these meetings together, and both of us would then be able to talk to each other in real time about, well, how do we deal with this situation in Sierra Leone? There's a diplomatic track, but there's increasingly an accountability track. Also, I was coming just off of the Rome negotiations in 1998 for the Rome Statute of the International Criminal Court, which we had unfortunately not been able to support the final draft of. And there was a bit of pressure on me, which I imposed upon myself, quite frankly, to demonstrate that the United States was still cared about accountability, and therefore we would be there to support those tribunals that frankly fell outside of the temporal jurisdiction of the Rome Statute, because that wasn't going to happen until 2002, the actual creation of the court. So this was the 1990s, and we had a lot of work to do on accountability. We had supported Yugoslav and Rwanda tribunals, and now here was Sierra Leone. And it was my intention we were going to be front and center on Sierra Leone. So that enabled me then to inject myself into discussions not only in Washington, but also in New York, as well as in Sierra Leone with the government of Sierra Leone, to address the issue of accountability, particularly as the civil war erupted again, particularly in early 2000. Then accountability really had to be addressed very directly. And I was fortunate enough to be in office in order to do that.
Well, that's a great introduction. And let's now turn to Ambassador Hans Carell. Hans, you were the Undersecretary General for Legal Affairs of the United Nations at the time of the conflict that David was just describing. And David mentioned the existence of the Yugoslavia Tribunal and the Rwanda Tribunal. Those were created by the Security Council. Why wasn't a Security Council established ad hoc tribunal like those created for Sierra Leone? Why did you come up with the idea of a hybrid tribunal? You're on mute, Hans.
Yes, thank you for the invitation. It's very interesting to be present on this panel. And David Sheffer, your introduction here was very important to have this background. When I was faced with this, my background was that I'd been on the bench for 10 years in my country, Sweden, between 1962 and 72. And then while I was a war crimes rapporteur in the former Yugoslavia in 92-93, appointed by the Conference on Security and Cooperation in Europe. And then I came to the UN in March 2004 as legal counsel, and I served in that position for 10 years. So this is what I had as a background. And I was also Kofi Annan's personal representative at the Rome conference when the treaty for the establishment of the International Criminal Court was negotiated. But when this really struck me was on the 9th of August 2000, when the president of the UN Security Council received a letter dated 12 June 2000 from President Kaba of Sierra Leone, requesting the Security Council to establish a court of the same nature as with the ICTY and ICTR. And of course, I had been deeply involved with the establishment of these two courts, because when I came to the UN, they have just started developing the ICTY. And then, of course, I was sent to Rwanda in November 1994 to convince President Bizimungu and others that they should cooperate with the Rwanda Tribunal. So I had that background. But when the discussion started in the Security Council, it turned out that the Council was not prepared to establish yet another court of this nature. And therefore, on the 14th of August 2000, the Security Council requested the Secretary General to negotiate an agreement with Sierra Leone to create an independent special court through Resolution 1315/2000. And we started this operation. And the first stage, there was a negotiation held at the UN headquarters from 12 to 14 September 2000. And following this, a UN team led by my deputy, Ralph Zachlin, visited Sierra Leone from 18 to 20 September 2000. And this led to a report by the Secretary General to the Security Council on the 4th of October 2000. The number is S/2000-915. Now, the Security Council focused on the situation in Sierra Leone. On 20 March, for example, they adopted a resolution, and on the 18th of September 2001, they adopted a resolution 1370. But there was a planning mission, and that was sent to Sierra Leone on the 7th to 19th January 2002. And during that period before that, I had negotiated with the Sierra Leoneans, and the whole thing emanated in an agreement between the United Nations and Sierra Leone on the 16th of January 2002. And I signed the agreement then with Solomon Boreva, the Minister of Justice of Sierra Leone. And I must say that when I look back to this, I had a very positive experience when I negotiated the agreement between the UN and Sierra Leone on the establishment of the special court. And for my part, I have no doubt whatsoever that the government of Sierra Leone was deeply committed to creating a genuine, independent and impartial tribunal. And my counterpart was, as I remember, Solomon Boreva, who was then Minister of Justice. He was very cooperative and fully understood that an agreement with the UN must observe the standards that apply with respect to criminal justice under international law. And in particular, since the court would have both national and international judges, he fully understood that the majority of the judges in the chambers had to be international judges. As a matter of fact, when the government of Sierra Leone made its first nomination of judges to the court, their proposal included a judge from another country. On the 28th of March 2002, the Security Council welcomed the agreement of the 16th of January same year and urged donors urgently to disperse the pledges to the trust fund for the special court. And it looked forward also to the court expeditiously beginning its operations. This was through the resolution 1400/2002. On the 24th of September 2002, the Security Council welcomed the launch of the special court through resolution 1436/2002. And I must say I was impressed by the manner in which the court came into function. It was very, very professional work behind that. And the Security Council has since then reverted to the special court many times, reiterating its strong support for the court and appealing to states to contribute. And of particular importance, I would here mention Resolution 1688 of 2006, where the Council, now acting under Chapter 7 of the UN Charter, requested states to contribute to ensure the appearance of former President Taylor in the Netherlands for the purpose of a trial before the special court. Because during the negotiations, we had agreed that if, for security reasons, it was not really advisable to hold a trial in Sierra Leone before the court, the trial could be held elsewhere, and this was done in the Netherlands. So I think this is extremely important. So these are my, shall we say, memories of the process which the court was established. And I must say I was impressed then following the work of the court. I retired from the UN, as I mentioned, in 2004, but I followed the work at a distance, and I'm extremely impressed by what the court achieved. Thank you very much.
Hans, let me ask a follow-up. So you've described the creation of this court as not by the Security Council. You've said the Security Council merely welcomed it. It didn't authorize it. It didn't mandate it. But rather it was created by this exchange of letters with the government of Sierra Leone and your office, or the Secretary General's office. What are the legal significance or implications of the different way that this court was established versus the ad hoc tribunals?
Well, I think it's a very, very interesting development we saw here. I mean, as I said, I was involved in the creation of the ICTY and ICTR, but it turned out, as I said, the Security Council was not prepared to establish yet another court of this size. So therefore, in the discussions, they wanted the Secretary General to negotiate an agreement with Sierra Leone. But the interesting thing is that one element in this process was a question: could this special court use the trial, the appeals chamber of Sierra Leone, of the Rwanda or Yugoslav tribunals as an appeals chamber for the special court? But during negotiations, we found that it was more relevant and proper to negotiate an agreement on a special court in all instances. So this is why we have this agreement. And I think it's very important because it demonstrates that it is possible for the UN to conclude at the request of a state a court of this nature. And I will come back to the differences between the Cambodia and Sierra Leone Tribunal later in our discussions. But I found that the manner in which the Sierra Leone court was negotiated was extremely important, and the manner in which the court resolved its duties was extremely important. And now when we are looking at the situation in Ukraine, I think there is a lot to be learned from the process in the establishment of this special court of Sierra Leone. But I think this will come up later in our discussion. Thank you.
While we're on the subject of the Cambodia Tribunal, let me just return to David Shepard. David, you were involved in the creation of that tribunal, and I'm curious as to how the Special Court for Sierra Leone differed from the Cambodia Tribunal.
Well, there were significant differences and significant similarities. The difference with the Cambodia Tribunal is first and foremost the UN resolution that triggered the process of finalizing the terms of of creating that tribunal came from a resolution of the General Assembly, as opposed to the Sierra Leone Special Court, which was a resolution by the Security Council. Both of those resolutions, however, had similarities in that they recommended to the Secretary General to negotiate the creation of the court with the subject government, whether it be Sierra Leone or Cambodia. So at the end of the day, and Hans Carell was the lead negotiator on both of these courts, the negotiations were fulfilled, and ultimately a moment arrived whereby an agreement, namely a treaty between the United Nations as a institution of international legal personality, could enter into an agreement with a sovereign government to actually create a court. But there were significant differences in how each process evolved. With Sierra Leone, it was an ongoing civil war. Things were extremely dynamic. UN peacekeepers were being held hostage. there was a tremendous amount of diplomatic activity. The UN was engaged because everything was kind of blowing up in May of 2000. And so it was possible for people like me, representing the United States, to get discussions moving towards how to deal with a very dynamic civil war situation, similar to, the fact, remember, in Yugoslavia, in the former Yugoslavia, the war raged when we created the Yugoslav Tribunal. In Rwanda, the genocide had just subsided when we created the tribunal. But in Cambodia, these were the Pol Pot atrocities of the late 1970s. And so therefore, it was much more difficult to seize the attention of relevant parties at the United Nations in the late 1990s to suddenly turn their attention towards accountability for the Pol Pot atrocities of 25 years hence or earlier, particularly when the United Nations was just wrapping up or had just wrapped up a large peacekeeping presence in Cambodia. There was no notion that there was a threat to international peace and security anymore. So how could the Security Council pay much focus to Cambodia? So the Cambodia situation was much more difficult to get started. It did require intensive negotiations and discussions with the government of Cambodia under Hun Sen, which was not human rights friendly, was a very different government from the government of Kaba in Sierra Leone in terms of having a negotiating party across the table. I'm sure that Hans Carell would agree with me. It was like night and day negotiating with the Kaba government versus negotiating with the Hun Sen government. And each had sort of different priorities in what they wanted out of the tribunal. The Kaba government wanted a fairly broad scope of attention to what happened in Sierra Leone during the Civil War, including with child soldiers, including holding them accountable. And the Cambodia court, the Hun Sen government, wanted basically a pretty small list of indicted individuals to stand trial before the court. I remember, Hans, we had a list at some point at, working with you at the UN where we listed at least about 30 individuals who could easily stand trial for the Pol Pot atrocities. And yet the Cambodian government said, no way, we don't want to go up to 30. And so it became a very difficult process. And finally, I'll just conclude with this. The great difference between the two was that the Special Court for Sierra Leone was an internationally dominant court. In other words, it ultimately was deemed to be an international tribunal. It had the role of the UN was very dominant in creating that court. It had a majority role in the number of judges, a chief prosecutor, et cetera, and the administration of the court. Whereas with the Cambodia Tribunal, that was a domestic Cambodian special court, the extraordinary chambers. That's why the word extraordinary is in there. And it was not an international tribunal. The UN had deep immersion in that court through an agreement, but it was in the minority position in the court in terms of judges. It had to share co-prosecution, co-investigating judges, and it had to deal with sort of the civil law tradition of Cambodia. So it became a much more complicated formula to negotiate.
Yes, I must say it was extremely difficult. And I can tell you that we were so disappointed, Kofi Annan and I, that when we had signed the agreement with Sierra Leone in January, Kofi Annan decided to withdraw in February the same year from the negotiations with Cambodia. But we were forced back to the negotiations by the General Assembly through a resolution in December 2002. And this meant that I had to go to Phnom Penh again, and I negotiated with Sok An, who was my counterpart, the final agreement. But I was very worried, even if though this was presented to the General Assembly and they approved of the agreement. And then I signed it with Sok An on the 6th of June, 2003. But I was extremely worried, and some of the things that I had warned against has occurred. At the same time, I understood that the international judges and prosecutors and others who would serve on this court, they would do their very best to have it function as it should. But for the simple reason that David Shepard mentioned here, it was not a truly international court. It was chambers in the national courts of Cambodia, and the majority in the chambers, they were Cambodians. But I would say that the important lesson from this is that the General Assembly can be approached by a state asking for a court. So in my view, the method that was used in Cambodia could be very efficient if, for example, Ukraine would wish to have a similar court. But the agreement with the country should be based on the Sierra Leone agreement. This is my very firm view. Thank you.
That's a great insight. And we are going to come back to the question of how this all applies in the Ukraine in a few minutes. But there was something that David Shepard said that I do want to emphasize, and I'll put it in this context. A couple of days ago, the producers of 60 Minutes called me up. They're going to be doing a special episode in the fall about accountability in the Ukraine. And they said, isn't it true, Dean Scharf, that these courts really don't ever get started till years after the conflict? And Ambassador Shepard, I think, made it very clear the history that disproves that in fact, there have been successful tribunals and accountability mechanisms established during the conflict, and they played a role. They didn't have to wait till the conclusion and years later. Let me turn now to Register Binta Menasari and talk to you about the costs of the Special Court for Sierra Leone. We often know, in international institutions and organizations, that's the most important issue. And can you tell us who paid the bill for the Special Court and what was the budget of the tribunal?
Good morning. Let me thank you, the organizers, for giving me the opportunity to participate in this webinar. The Special Court for Sierra Leone, by the time it's finished, on average for the 10.5 years it was in operation, would say $24 million per annum was the budget. But in totality, that would amount to about $270 million for all of its operations for the 10.5 years. And the way it was established, it's based on voluntary contributions. That means it has no certain source of funding where it would have a certain percentage like other tribunals. Lebanon, perhaps somebody paying a portion of the bill. So it's based entirely on voluntary contributions. And that means we rely on the goodwill of states, on the goodwill of donors. So the court fundraises all the time to secure voluntary contributions. So in essence, those who paid the bill are member states of the United Nations on a bilateral level, but also foundations had contributed because we had the restricted and non-restricted funding mechanism that we use. So foundations provide earmarked contributions to, as restricted contributions for special projects, basically, projects that cannot be funded by voluntary contributions. For example, outreach. Outreach was not funded, was not part of the core budget of the court, so it fell under the restricted funding, and it was funded largely by the European Union, the outreach activities and other foundations. But when you look at the core funding, we have many member states. We had large donors, mid-level donors, and small contributors. And among the large donors were the United States, United Kingdom, the Netherlands, Canada, Germany. So those were the large donors, but the others, as I mentioned, are just mid-level donors. European countries, most of the European countries fall in that category, and we also had small contributors. So that's how we were funded.
Binta,
Of
can
course,
I ask you,
can you hear?
did you ever run low on funding at any point, and that was a difficulty for the court?
I was just going to add to the fact that where voluntary contributions were not sufficient, especially towards the latter part of the court's life. And during the Taylor trial in particular, we resorted to seeking subvention from the United Nations. So the United Nations provided subventions 3-4 times to the Special Court for Sierra Leone. And of course, we ran short of funding. Again, that's where the subvention was important because of the voluntary contribution nature of the court. We were never in a position where we secured sufficient funds for the whole year. So we had to just do it maybe on a quarterly basis. The prosecutor, the registrars, all court officials were just running all over the place, all over the world, while at the same time doing their work to make sure that if we had funded for 3 months, by the time the funding runs out, we had money for the following quarter. So that's how it was. It was extremely difficult, a very uncertain way of executing the mandate of the court.
And Binta, I've heard it said that the Special Court for Sierra Leone was the most cost-effective of any of the international tribunals created to date. How did its budget compare to the other tribunals, and how was it able to succeed with such a small budget?
Yes, our budget, we were cost effective. And again, we just need to put into perspective when we say we are cost effective and when we compare the Special Court with other tribunals, because we operate, the mandates were different, the context of operations were different, the duration of the lifespan of these tribunals were different. So it's a kind of tricky thing to compare cost. And when we are also talking about cost, what have we achieved apart from just the trials? I mean, people differ. There are many perspectives out there. For instance, some say that if you divide the total budget of courts by the number of accused, then you get the per accused cost of the trial. For example, Special Court for Sierra Leone, if you see 270,000 for it's almost a 10.5 to 11 year lifespan. Some would say it costs like 20 point something million per accused person. If we go to the ICTY in a similar period, the 10-year period, spent about $700 million. ICTR almost $1 billion for the same period, but they indicted also more people for that kind of money. So if you're using that particular formula, which I think is a false formula, but just for the purpose of this webinar, if you're using that formula, you would say that the ICTY for a similar period had about $4 or $5 million, spent about $4 or $5 million per accused person, because they indicted about 161 individuals. And ICTY, you would say $11 million per accused person, because they indicted about 91 persons. But then you come to Cambodia Tribunal, and you may even want to look at the ICC for if we are extending that formula for a decade formula. In Cambodia, they spent about between $270 to $292 million for a 10-year period from 2006 to 2016. So if you're looking at per accused person, you're talking about anywhere between $37 and $40 million per accused person. And you go to the ICC for a similar period, they spent about $900 million. So per accused person, you're talking about $60 million. But so that is what the cost is like. Again, as I say, I always hesitate to do this comparative analysis, because when you look at what these tribunals have achieved, the special court achieved a lot more than just putting one person, on trial. Because we were based in the country, we were able to have an impact on peace and stability in the country. We were able to have an impact on reforms that were, going on in the country. So if you look at all those benefits and weighing it against the cost, yes, we can come to the conclusion that we were a lot more cost effective than other tribunals. Thank you.
Thank you, Pinta. And I'm really glad you made that last point, because some people look at these numbers and they're thinking, wow, what a waste of international resources. But as you say, if a tribunal can add to peace and reconciliation, stop the fighting from resuming, it's a whole lot cheaper than sending in a peacekeeping force or sending in very expensive aircraft. For example, the amounts of money that the United States is helping Ukraine with dwarf by far anything that you're talking about in the costs of this tribunal. Let's turn it over to David Crane. So David, where we are in this recounting of the Special Court for Sierra Leone is we've heard the background, why it was created, we heard about the negotiations, we heard how it was funded. And now to get things going, they have to have a prosecutor, and that's where you come in. Will you tell us the story about how you found out that you were the prosecutor and how you readied the first prosecutions?
Well, thank you. And I just want to say thank you to all my colleagues that are here today. Over the years that we've known each other, but particularly during those very difficult times that we came together to seek justice for the people in West Africa as well as Sierra Leone. Each and every one of you were particularly important in its success. And a great shout out to Case Western Reserve University School of Law, who has always been there for the Special Court for Sierra Leone and provided great, important research, interns, and just moral support throughout the years. So my compliments to all of you, and I'm humbled to call you friend, because again, each and every one of you were important in the success of the Special Court for Sierra Leone. I didn't want the job, never even contemplated. I was a senior executive in the Department of Defense. I had a great career going. I got a call on August 27th of 2001 from David Shepard's office saying, would you be interested in possibly being the chief prosecutor of this new tribunal that they're creating? And I basically laughed at them saying, you got to be kidding me. They're not going to pick an American. And basically said, yeah, I'd be interested, and kind of hung up on them. And then 6 months later, after working with Hans, getting to know Hans, we had worked together in the 50th anniversary of the Nuremberg trials many years earlier. But I saw Hans again. There was great skepticism for me personally and an American in general. I never contemplated that I'd actually get the job. A week before I got the job, I was told that you're not going to get the job. And I promptly took my file and put it in my drawer and forgot about it. And then on the 19th of April of 2002, my secretary walks into my office and said, there's a Hans Carell on the line. This is about 11:25 on that Friday morning. And Hans called me and said, congratulations, you have been chosen to be the chief prosecutor, and I hope you'll accept the job. I had just told my wife a couple days earlier that I wasn't going to get it, but of course I would take the job because I felt I could do the job. And he says, well, that's great, because at noon I'm going to announce that to the world, which he did. And the phone calls started coming in. But during this time frame, I'd already started shaping and molding a 10-phase strategy of beginning, middle, and end, how we're going to accomplish our mandate, which was greatest responsibility, which is the correct mandate for an international tribunal. The Rwanda and Yugoslavia tribunals had those responsible, which could be hundreds of thousands of people. Here, very much like Nuremberg, I focused and considered greatest responsibilities. This is the first time it was ever used. Those who were actually created the conditions, the leaders of the various factions. And so that's what I did. And off we went. And on 1 July of 2002, Robin Vincent, the new registrar, and I went down to the Chase Manhattan Bank and deposited $1. in the account of the special court for Sierra Leone. And then Robin looked at me and said, well, let's go have a beer, which we did. On the 6th of August of that very same year, I stepped off an airplane into a totally devastated Mad Max Thunderdome scenario. And we began our work, which everybody that is on this webinar played an important part.
So, David, one of the things that was perhaps the most publicly visible contributions of your tenure was your decision to boldly go forward and indict the president of Liberia, Charles Taylor. And I understand that at the time there were some countries that weren't too thrilled with that, maybe the timing of it or the decision. Will you tell us that story?
Well, you know, it's interesting. You know, I think that Hans Carell and along with David Shepard and others correctly anticipated certain things that were going to happen. Child soldiers is one of them. Let's put that in the statute as well. And they also gave us that really workable mandate, greatest responsibility, which is now the standard by which international tribunals really look at an atrocity. So that was, you know, that was very important. But also in the particular statute itself, the creative statute, it said that it basically said that any heads of state that possibly could be involved in this could be considered. Well, of course, I had been studying Sierra Leone for months during my interview process and stuff, and I realized I already had a list of those individuals who I thought bore the greatest responsibility, and I had 3 heads of state in my gun sights, so to speak, at first. Muammar Gaddafi of Libya, Blaise Compaoré of Burkina Faso, and of course, President Charles Taylor next door in Liberia. Each and every one of them were directly involved in the tragedy that was Sierra Leone and largely the destabilization of all of West Africa. Of course, the bright red thread of international criminal law is politics, not with a big P, but with a small p. You have to consider the political ramifications of indicting potentially 3 heads of state. I think it would have been the end of the special court for Sierra Leone. So I decided to look at, really based on facts and law, someone I could actually convict, and that was President Charles Taylor. He was directly involved, though frankly the other 2 were too, but I chose for political reasons and for focus to investigate President Charles Taylor. So he was always the one person that I was going to indict. Of course, the heads of the Civil Defense Force, the Revolution United Front, the Armed Forces Revolutionary Council were also individuals that I was going to look at. And I was certain that I had the correct individuals. And you know why? Because I went out and asked the people of Sierra Leone, who did this to you? Binta and I came together, created the outreach program, the town hall program, where we literally, my goal was to walk the entire country in the first 4 months that I was there. And we almost made it. I didn't quite get to Port Loco before we had a vacation break. But the people of Sierra, I asked them, who did this to you? And they would name the individuals that I had on my list who I was most likely, in fact, my investigators and team were already investigating, those who bore the greatest responsibility. But Charles Taylor, and they would bring him up. And I said, well, look, I'm going to take all this back. I said, don't believe what I do. Don't believe what I say, believe what I do. And so Charles Taylor was always on my radar screen. But the important thing is that when you're thinking of indicting a head of state, you have to do it perfectly, and you can't make a mistake. And so Brenda and I and all of our teams were working together and putting out the indictments. But one of the standards that I had was that we had to have at least 2 of the charges of all of those who bore the greatest responsibility before I signed, provable beyond a reasonable doubt. And they had to show me that. And so when I did sign the indictments, to include indictment number 1, President Charles Yankee Arthur MacArthur Taylor, president of Sierra Leone, we already had a solid case against him. Of course, you can't just automatically issue the indictment, because I thought politically it would really destabilize the country. I had to time the issuing of that indictment. So I sealed that indictment, but we announced the indictments of the others just at the beginning of Operation Justice in March of 2002. So we unsealed the indictment of President Charles Taylor as he was going to Ghana to enter in some kind of peace accord. I timed it specifically for that. I wanted to show the world at the stroke of my pen, you can take down the most powerful warlord in Africa and send a signal to the good old boy network of Africa, but also to all tyrants around the world that you are not above the law.
But they didn't arrest him at that very moment. And so I want to turn to Jim Johnson and Brenda Hollis, who were there in Freetown at the time of his arrest and surrender, to tell us the background of that part of the story. Brenda, do you want to start? You're on mute, though.
It was in many ways surreal. It was actually Desmond de Silva that energized the world and convinced them that it was time to hand Charles Taylor over to us after Ellen Sirleaf Johnson Sirleaf became the president in Liberia. And so he managed to get all these countries to agree to push for it. And then it happened. And once it started off, it happened really quickly. And I'm sure Jim remembers they were going to fly him in by helicopter. So we had to put down a helipad, and it hadn't even cured by the time the helicopter landed because it had been so quick. And it was evening was coming on when they brought him in. And the interesting thing, as Dave said, the people of Sierra Leone always mention Charles Taylor as among those who has greatest responsibility for these crimes. And the court was ringed by people on roofs and up on poles to watch this man being brought to justice finally in their country for the devastation he had inflicted on that country. And so it was amazing to be there and to be part of that and to see it, but more amazing to see the impact of it on the people he had victimized for so many years.
Do you want to add anything?
Well, yeah, and maybe a few thoughts, and just to that last thought of what Brenda mentioned, the people that ring the court, and you know, Brenda and I were standing there just probably about 100 meters from the helipad when the helicopter came in, and by the way, we didn't know until the last minute whether that helicopter would come into our helipad or whether it would come into the UN helipad, which was down by the beach. And so we were all watching, and we knew it was on its way, and pretty soon 3 helicopters came flying over the hill, 3 UN helicopters from the mission in Liberia, and set down on our helipad. And you know, when the noise settled down, the helicopter shut off and the noise settled down, we heard all of this cheering. And we didn't know where it was coming from. We couldn't figure it out. And we finally looked around us, and lining the top of the buildings along the one wall of the court complex were people. And how word got out on when his helicopter was coming in and where to be, we're not sure at this point. But it was quite a feeling. As Brenda mentioned, it was very much a surreal feeling to see that those helicopters coming over the hill. And what was interesting was that, well, I think that was a Wednesday, wasn't it, Brenda, that he came in? And
I don't remember, Jim.
I think it was a Wednesday. And on Monday of that week, we were told that we knew things were getting close. We knew that something was going to happen. And on Monday of that week, we were told that Charles Taylor had disappeared, that he had escaped from his exiled home in Nigeria, a resort town along the ocean, that he had escaped and that he was gone. And so we were pretty down for a day or two, thinking we got him. And then we got a call that morning and said, nope, Charles Taylor has been found and he's on his way to Monrovia, to Liberia. And we fortunately at the time had 2 investigators on the ground in Liberia, and they met him at the helicopter when the helicopter landed, or the jet, the Nigerian presidential jet landed at Roberts Airfield in Monrovia, and they were there. And Charles Taylor had a very, very quick medical exam, was placed on a helicopter. Our investigators were with him on that helicopter, and of course, made the short flight from Liberia to Sierra Leone.
For those of you who have not been to Freetown, if you look at the background of Jim Johnson's image, you're looking at the Special Court for Sierra Leone building. So thank you for sharing that with us. Let me turn to Binta. Once the trial of Charles Taylor was about to start, suddenly it was moved to The Hague. Can you tell us about that decision and what the logistics were about that?
Yes, first of all, in the agreement establishing the Special Court for Sierra Leone, it anticipates a change of venue if circumstances so require. And Charles Taylor's trial was one of those circumstances which the president of the court at that time felt, would necessitate a change of venue of the Special Court for Sierra Leone. So he held consultations, diplomatic consultations about possible venues. They tried to see if it would be possible for the trial to be held at the ICTR. That was impossible because the ICTR was fully engaged with these trials. So there was no courtroom available. Consultations were held with the Netherlands, the Dutch government, and the Dutch government imposed certain conditions to be met before they could accept hosting the trial. And those conditions were a Security Council resolution supporting the change of venue, and also a country willing to take Mr. Taylor after the final judgment, whatever that judgment may be, and then a facility, an international court that was willing to make its facility available. So all of those conditions were met. Security Council resolution noted that Mr. Taylor's continued presence in the region was in Sierra Leone was an impediment to peace and stability, not only in Sierra Leone, but in Liberia and the sub-region. And also international, it would affect international peace and security. So all of the considerations, once the consultations had been held, the Security Council resolution has paved the way for the Netherlands to host the trial. The president of the court issued an order for change of venue. But the president of the court, this was not just politicians talking about security issues. The president of the court seriously considered security issues and the interests also of Sierra Leoneans, witnesses, victims, all the logistical challenges that would moving the trial to The Hague would pose. And in its order, he directed that the registrar take measures to make sure that the trial was made accessible to the people of Sierra Leone and the region. So some of the logistical challenges, of course, witness transfer from Sierra Leone or Liberia to The Hague. Again, that was overcome because we successfully transported all the witnesses who testified before the Taylor trial. And then in terms of making the trial accessible, the video link radio programs, we had some challenges there because of the video link issues. Sometimes, they buffer, but we had trial summaries. Our public affairs office produced trial summaries that were disseminated, by a video mobile unit to play for the people of Sierra Leone. BBC World Service Trust did an excellent job in terms of training journalists and developing radio programs of the trial itself that were disseminated through community radio stations. So people learned about the Taylor trial. They followed it largely, and successfully through radio. So those are some of the logistical challenges that we had to overcome.
Thank you, Binta. And I want to talk more about the Taylor trial in a minute, but before we do, I think we'd be remiss if we don't recognize that there were a number of other very important trials and important precedents. So I want to go back to Brenda Hollis. You were there for a long time. So were you, Jim Johnson. Can you just tell us about some of the other cases and the important precedents that they set before we talk about the Taylor trial?
Sure. I mean, the title of this program, the little engine that could, not only could it did. And so the special court did many things and they did it very, very well. And just in terms of procedurally, I think one of the things that they did that was very, very smart was to accept the motion to dismiss the Taylor case based on a lack of jurisdiction, even though we did not have him in custody. Because if that was successful, there'd be no case. And so I think it was very smart of them to take it and also to immediately move it up to the appeal chamber for decision, because that's where it ultimately would go. But of course, in terms of other cases before the court, I think it was the CDF case that actually started the evidence on child soldiers. Although eventually I think it was the AFRC that came out with the first decision on it. Prior to that, of course, there had been a motion to dismiss because the argument was that at the time of the conduct, it was not a crime that incurred individual criminal responsibility. And I must say that reading the majority judgment and reading Judge Robertson's dissent, I find his dissent, at least in terms of enlistment, very compelling. Not in terms of conscription, not in terms of use in active hostilities, but enlistment, I found that his position was very compelling, but it was the minority decision. So the case did go forward. And it was the jurisprudence that was very, very important in terms of just factually, how do you determine a child's age? How do you know they're under 15? And the courts looked at physical appearance because some of the kids were so young that you could just look at them and know that they were not 15. It was an interesting cultural argument raised with that, in that you're comparing it to European and Western children's sizes, but in Africa, that doesn't necessarily flow. But when you looked at some of these kids whose weapon was bigger than they were, you knew that certainly they were under 15. And they also, of course, had some records that showed some children, some parents knew when the children were born, so they had some records to prove that. But interestingly, they also looked at the practice of these rebel groups to take underage children. So the practice itself became part of the evidence they used to determine beyond a reasonable doubt that they were guilty of this crime. So the enlistment, conscription, and use of children under 15 to participate in hostility is very, very important. Very important precedent, very important that the prosecution brought that charge. One of the things that, of course, as a prosecutor, you have to consider when you're bringing charges, if you're bringing a charge that has no settled jurisprudence, it's a big challenge. Was this conduct condemned, and was there individual responsibility at the time? What are the elements? What are the definitions? And so a prosecutor really has to determine what's the cost benefit here. Is it worth what it's going to take to prove it, to move forward with it? Or should we stick with other charges that are much better established? And hats off to the leadership of the Special Court Office of the Prosecutor to move forward with that. Of course, the other area, the other crime that they went forward with that had no precedent was attacks on peacekeepers. Very, very important to international peacekeeping efforts. And so again, very laudatory that they made the decision they would push forward with that. And that was of great significance as well. Also charging forced marriage, charging it itself was very important. And of course, if you look at the Taylor case, we didn't charge forced marriage in Taylor. Forced marriage, again, it was AFRC, and 2 judges said, no, that is part of sexual slavery. That's not a separate offense. And it was the dissent that said, yes, it is a separate offense. They should be found guilty of it. And it was only on appeal that the dissent, in fact, was upheld, establishing it as a separate offense. When we began the case in Charles Taylor, the appeal wasn't out yet. So we had a dissenting opinion. And quite honestly, looking at what happened in Sierra Leone, my view was that forced marriage in those circumstances wasn't the proper legal characterization. Now, if you look at what happened in Cambodia, I think forced marriage very much the proper legal characterization. But there, I just didn't think it was. I thought it was a form of sexual slavery. And in the Taylor case, that's what the judges decided after, of course, taking a swipe at the prosecution for misleading them by charging forced marriage in other cases. You know, that's par for the course if you're a prosecutor.
And I'll say one of the most significant aspects of what you're describing is these precedents that have then been cited, especially by the International Criminal Court over and over and over again. I think there are more precedents cited from the Special Court for Sierra Leone in the ICC than in any of the other tribunals. And most of those cases are not the Charles Taylor trial. But I do want to talk a bit about Charles Taylor. And in one part of this, especially I think our audience will find this really interesting, it's the only trial in history where a supermodel ever testified. So let's hear the story about that, Brenda.
You know, it was very interesting. We had closed our case, and we were getting ready for the defense case. And one of our prosecutors took a vacation. And while he was on vacation, a friend of his turned out to have been involved with Charles Taylor in a certain capacity. And he was telling this very amusing story about Charles Taylor sort of crashing the party that Nelson Mandela had thrown for this charity event, and that there was this model there, and that during the evening, Charles Taylor was flirting with this model and she was flirting back. They were getting along very well. And then after that, Charles Taylor sent these diamonds to her. Well, that was very relevant for us because our case in chief had been, this was shortly after he became president. He's doing sort of a victory tour. And our evidence was that shortly after he became president, on this victory tour, he got diamonds from Sierra Leone and used those diamonds to purchase weapons that he then sent to Sierra Leone. So this fit in very nicely with our evidence in our case in chief. So we asked that we be allowed to reopen the case to present this evidence. Now, I must candidly admit I made a tactical blunder. I never should have listed Naomi Campbell as a prosecution witness. I should have said she's a material witness to this evidence, to this count, and she should be a court witness because she never would speak to us, ever. Her agents wouldn't tell us anything. She wouldn't tell us anything. So I should have said, no, we can't call her. I don't know if she's going to be truthful. I can't really present her, but we did. And of course, she wasn't very truthful in her testimony, but it was weird because she said, well, she was at this dinner and there was this guy there. And after the dinner, they were in this hotel and these people knocked on her door and they brought her some stones. She just thought they were pebbles, but she kept them anyway. And the next day, even though they were pebbles, she gave them to someone to use for this charity event. So the whole thing was a little bizarre. The sad thing about it, though, Michael, was that here was this very entitled woman who had become very wealthy and had been courted by all of these people. She had a very rich Russian that she was with. And the gallery was overflowing and they had to have a media room that was overflowing. But we had people come to that court who were living among the perpetrators who had lost their limbs, who had lost their families, who had lost everything. And you would have a scattering of people that would attend those hearings. And yet for this person, you had all of this media and popular interest. I found that really in many ways very, very disconcerting. It's interesting that they had TV vans outside and this big media presence. And the Monday after her testimony, there was a gas station that had a little food mart close to the court. And I would stop in there and get a sandwich for lunch. And I became acquainted with one of the attendants there. And so I went in and I said, oh, last week, did you see all the media vans and everything there? And she said, yes, I did. And I said, she said, they showed this woman on television. And I said, well, what'd you think? And she said, I think she lied. So this is somebody who had no idea about what was going on, but she got it right. So that's the Naomi, but it just it just came up in a conversation, or we never would have known about it at all. And of course, it wasn't just her, it was also Mia Farrow and the woman that had been Naomi Campbell's agent at the time, who corroborated this thing that she talked about getting a diamond from Charles Taylor.
Well, one of the things that's true about prosecuting heads of state, leaders, they are often the most messy of international trials. And you could point to the Slobodan Milosevic case, the Saddam Hussein trial. And I want to ask Jim, how did the Charles Taylor trial compare to that? Was it a messy trial, or did Taylor and his lawyers play by the rules?
Well, again, Brenda might be the better one to comment on this, but maybe I'll just say that I think often they attempted to try this case in the public forum as opposed to in the courtroom. And I think that often we always wondered who liked to talk more, the defense counsel or Charles Taylor, particularly in his cross-examination. But I think that it wasn't the messy trial that you saw in Milosevic, but I do think that they did at times try the case in the public, in the media, versus in the courtroom where it should have stayed. I may be speaking on for Brenda here when I say that they would often make public comments and comment about trial and comment about the witnesses that as a prosecution, we felt restrained to comment back. And we felt restrained in the media to defend our position on things. And I think that that's unfortunate. And so I don't know.
I have one eye on the clock. I want to make sure there's 15 minutes for Q&A. So I want to get to one last area of questions, and that is something that Ambassador Hans Carell previewed for us, and that is the relevance of the Special Court for Sierra Leone model for what is currently being discussed for the Ukraine. And I know that David Crane and I think David Shepard and others are involved in these discussions behind the scenes to create a ad hoc tribunal, a hybrid tribunal for the crime of aggression. Dave, do you want to start us off on this? And that's David Crane.
Well, thank you. Yes, I think it's very relevant. I'd like to tell our audience and frankly the world, we've done this before. We've created a tribunal, a special court, call it a special tribunal, with a mandate of doing, among other things, prosecuting potentially a sitting head of state. So it's a great model by which we can shape and mold an appropriate justice mechanism for the people of Ukraine. The Global Accountability Network, which I'm a part of, will be actually publishing on the 6th of July a practical guide on how to set up the special tribunal for Ukraine on the crime of aggression, taking lessons learned to include my 10-phase strategy that I put together when we put together the first hybrid international war crimes tribunal. Hans has it right as well. We could take the previous model, use it as a template. The white paper that's coming out next Tuesday takes all of that and lays out for the international community and the people of Ukraine the ability by which we can fairly expeditiously and appropriately, of course, create an aggression tribunal. We have to do it. We cannot let aggression be pushed aside for whatever reason. This is really the center point crime of Ukraine, because from there, all the rest of the tragedy takes place. There are a dozen strong men around the world are watching this like crocodiles, waiting to see what the world's democracies do about this. So we have to create some justice mechanism. I'm obviously advocating a special tribunal for Ukraine on the crime of aggression, but we have to do that because the world will be a much darker place otherwise.
Do any of the other panelists want to comment on that question?
Well, if I may add just that I found that the Sierra Leone court functioned so well that it could very well stand as a model But in Sierra Leone, the court was sitting in Sierra Leone, except when Charles Taylor was tried. If Ukraine would wish to have a similar court, I think it would be wiser to place the court in The Hague, next to the ICC, for two reasons. First of all, security, and secondly, because almost all the evidence that the ICC will be collecting could be used by the special court. When you add also the fundamental piece of evidence, namely the declaration by the president of Russia when they attacked Ukraine. I think it's a tragedy. I didn't think I would, shall we say, experience this in my life, that again, we would have what happened in Europe back in those days. So I think it's very, very tragic, but therefore it is important that the state community demonstrates that we do not accept this kind of thing happening. We have to establish a court, and only if even if there's only a prosecutor there who can make an investigation and formulate an, shall we say, an indictment, this should be published so that the world can see what the person in question is suspected of, even if we can't find him or that he cannot be brought before the court. It's important that the world can see why an objective prosecutor has found and formulated in an indictment. Thank you.
Hey, Hans, one of the things that
One of the
things that's very interesting, and which we're looking at very closely, is and it's never been talked of that I'm aware of, and correct me if I'm wrong, but can one aid and abet an aggression? And if that is so, then we have others who can, in fact, be brought before an aggression tribunal as well. And we're looking very closely at that, so that it's not just Putin, but those who actually took and aided and abetted that particular aggressive act.
Indeed. If I may, Dave, I think you can, I think very clearly you can aid and abet an aggression. I would certainly be happy to move forward with that sort of charge.
That's my thinking
too. It seems to me that, yeah, and it seems to me that if you're going to have a court to do that, that the Special Court for Sierra Leone is the model, and it would probably have Ukrainian judges, but I think the better model is to have a majority of international judges. It relieves the locals from any sort of pressure that could even be life-threatening for them. It's certainly here in Cambodia, I think politically couldn't happen, but it would have been better with an international majority here.
Yeah, we addressed that in the white paper as well, both security that Hans mentioned, but also the judge makeup and the experience of the judges that should be appointed, which you and I had many conversations over.
So the definition of aggression in the ICC statute is planning, preparation, initiation, or execution. And it would seem like aid and abetting would fall within those. David Shepard, let me give you the last word on this question, and then we're going to go to our chat, our Q&A.
Sure, thanks, Michael. I think for the audience, the significance of creating this special court on aggression is that without that crime being established in the Ukraine conflict, you are left with the ICC prosecuting individual war crimes, crimes against humanity, and possibly even genocide. And that would be without the benefit of the overarching crime, the umbrella crime, which is the crime of aggression, which triggers all of the other crimes. It seems to me that
exactly
that would leave the wrong impression with the public, as well as with, frankly, the perpetrators, that somehow they can invade a country and then we pick them off one by one with a war crimes charge, but all of their other aggression, all of their armed attacks on that territory are somehow left outside of criminal culpability. Frankly, all of the military activity of the Russian military on Ukraine territory today, I would argue, is illegal. It's illegal because it's part of the crime of aggression. That's a very important prosecutorial tool that I would think the ICC would want to have this sort of parallel aggression thing going on. And also in the aggression court, as has been noted, they'll want to be looking at all of the evidence collected by the ICC. There has to be a very good memo of understanding between the ICC and the Special Court for Ukraine on how they integrate their evidence bases. But it is a holistic approach that would result if we had the Special Court for Ukraine. And just one final point, remember, we're looking at a resolution recommending this out of the General Assembly, which was the Cambodia situation, as opposed to one out of the Security Council, which we won't get because of the Russian and Chinese vetoes. So that's a slight distinction between the two.
So all
1 minute.
excellent- Go ahead.
Sorry, just 1 minute. I think that even with war crimes, crimes against humanity, because of the level of the perpetrators you'll be looking at, a lot of the evidence establishing the aggressive attack on Ukraine would come in anyway as being relevant to the contextual elements. So I think that would come in, but it would not be highlighted as aggression, of course.
So it's really amazing that 20 years after the establishment of the Special Court for Sierra Leone, its precedents, its model are all more relevant today than ever, as we've been talking about its application potentially to Ukraine. We've got some great questions I'm about to turn to, but I do want to mention that if you were interested in getting your 1.5 hours of CLE credit, remain on the line at the end of the program, and Eric Seiler will give you the code so that you can get that. Now to the questions. I want to start with Valerie Osterveld. She says this question is for Binta and Jim. They are involved in the residual Special Court for Sierra Leone as the registrar and the current chief prosecutor of the residual court. And Valerie says, can you tell us a bit about the current activities of the residual Special Court for Sierra Leone?
Okay.
Binta, go ahead, please.
Okay. The residual Special Court for Sierra Leone is mandated to carry on the continuing legal obligations of the Special Court for Sierra Leone, which closed in December 2013. Basically, that includes supervision of enforcement of sentences, protection and support of witnesses, management and preservation of our archives, providing assistance to national authorities, and also trying Johnny Paul Koroma if he's apprehended, if alive, and his case is not transferred to a jurisdiction willing and able to try him. Currently, what we're doing is we continue those functions and providing protection to witnesses and I just have a mental, but Jim, you want to take over?
Jim, do you want to jump in?
Well, perhaps maybe I'd just like Binta to take just a minute too to discuss some of the recent outreach activities that she's been undertaking in Freetown, recognizing the 20th anniversary. And you know, Binta had a very, we touched on the groundbreaking outreach program in the Special Court for Sierra Leone, and that has very much continued in the residual Special Court, because you know we are 20 years after the end of the conflict. But you get very concerned that as memories fade and as a new generation comes up that didn't live through the conflict, in teaching them about the conflict and the conditions that created the conflict, and so that those conditions won't return. And so maybe Binta could just take a moment and mention a few words about some of the activities she's been involved in lately to keep the memory of that alive and the contribution of the court to peace and stability in the region.
Binta?
Okay, well, before I go to that, I thought you were going to talk about conditional early release. We monitor conditional prisoners, prisoners who have benefited from conditional early release. They continue to serve their sentences in their communities, but subject to strict conditions, and we monitor that as well. It's a very interesting program, but I'm mindful of time. If I start explaining, I don't know how much time I have, but we'll definitely be happy to share information on that. And the projects that Jim refers to is preserving the legacy of the Special Court for Sierra Leone in Sierra Leone, but also the challenges. For instance, I'm sitting here now in our archives room where we keep our public archives, a copy of our public archives. But these archives, given the low level of literacy in the country, would not be as meaningful as it should be if we do not package them in a format that is accessible to the people, that the people will be able to consume its content. And we have been doing that basically through this Peace Museum, using artifacts to explain the work of the court and its legacy, so that the people in remote parts of this country will understand what the Special Court, not only the Special Court for Sierra Leone, but also the Truth and Reconciliation Commission, what they did. They learn about the war, the peace process, and transitional justice. So that's every week we have twice a week we have students coming to the museum to learn about the war, because it's not being taught in schools. So we're trying to close that education gap. So that's some of what we're doing, but the president of the court is also engaged, in working, issuing directives for the courts to, carry out the directives relating to potential contempt of court issues, potential, I say. And that's just one of them. But we, as I mentioned, we would be happy to engage. We have lots of things.
And as I understand it, Charles Taylor is still filing briefs and motions, and there are still issues about protection of witnesses that Jim Johnson, you and your colleagues have been involved in. You want to mention anything about that?
Well, and sure, shortly, and I too appreciate we're running out of time, but Charles Taylor did recently file an application that was considered by our president and designated judge to have his place of confinement changed from the UK to somewhere else, where he felt he was less likely to get COVID, and that application was indeed turned down. We do still have witnesses that are approached and harassed because of the testimony and the evidence that they provided to the court. We of course take this very, very seriously, because they were very brave in coming forward in the first place, and we would not have been successful without the support of these witnesses. And so we react quickly. Binta, through her witness protection unit, often the local authorities and the local police, we react quickly to these approaches to our witnesses. We've also had witnesses approached seeking to, offering them inducements to recant their testimony. And of course, we've issued a press release about how that is also a contempt of court, and that we will certainly pursue contempt of court against anyone who unlawfully, improperly approaches our witnesses.
David, we have 1 minute left. I'm going to give you the final word on this panel, because I see that you have your hand up. But you're on mute.
Very, very quickly, and I'm learning a great deal, as I always do, from my colleagues on all of this. But the point is that two things. I remember when I was briefing the management committee in July of 2002, in the phase 10 of my strategic plan, I had a bullet in there called a follow-on court. And someone asked me, what is that? And I said, well, that, once we convict individuals, they're going to have to be monitored. They have to seek relief, so that we're going to have, I didn't call it a residual special court at the time. I called it a follow-on court. And they actually scoffed at that. Another real quick vignette was, why did we call it the little engine that could? And I think you and I had this chat. We encouraged academics to come to Freetown and do their research, which we did. We had a great professor of political science come from Beloit College in Wisconsin. It was our custom. The night before they left, we took them to dinner, a couple of senior members of the office of the prosecutor. And, I was just mentioning, she looked at me, she goes, "You're doing so much with so little." And I said, well, you could call us the little engine that could. Well, her subsequent publication that came out, title was The Little Engine That Could. So just a little vignette. as to why we call it the little engine that could.
Well, that's a great place to end. We are out of time, unfortunately, but what a great afternoon. I'm sure that the folks over at the ICC, that we've given them a run for their money. Let me do a really huge thank you to Ambassador Hans Carell, Ambassador David Shepard, Professor David Crane, Prosecutor Brenda J. Hollis, Registrar Binta Manasari, and Prosecutor Jim Johnson, my colleague at Case Western, for being with us and making history accessible to our audience today. Please stick on the line if you are interested in getting your CLE code, but everybody else, you're welcome to go and have a great weekend. I am wearing my 4th of July tie because here in the United States, it's a special weekend for us. Eric, do you want to tell us about